the court was like, well, if it's the same to you, then why even make the change?
Welcome to the Animal Law Podcast. On this episode, we are joined by Noah Greenwald, and he is the Endangered Species Program Director at the Center for Biological Diversity. He's been working on Endangered Species Act cases for around 30 years. And he is a bit different than most of our guests because he comes at animal law litigation from a somewhat different direction. He's not a lawyer, but works very closely with the lawyers and is, in this case, one of the declarants, who are, of course, a crucial part of endangered species litigation, and we'll talk about why. And he's here to talk about this incredibly important case in which the Northern District of California very recently struck down 4 of 6 challenged regulatory provisions. These had been put in place by the former Trump administration, then kind of fooled with by the Biden. Anyway, it's been a process, but we're just dealing with where we are now. And they're a problem, or they were a problem until this litigation came down. They drastically weakened 2 of the Act's core mechanisms. And the efforts to reduce the power of the Endangered Species Act have they've always existed. They've always been working on it, but they've never been more vehement, I think, than they are right now. And we're pleased to be able to unpack what is really an incredibly important case. So welcome, Noah. Thanks for joining us.
Thank you, Mariann.
And just a quick reminder about the Our Hen House podcast. Rising Anxieties comes out on Tuesdays, the Hen Report on Thursdays, and the long-form interview, including this one, on Fridays, and bonus for Flock members comes out on Mondays. So we're a podcast, we're on YouTube. Subscribe and hit like wherever you can. Let's start with just describing to us what your job is. You're the Endangered Species Program Director, but that doesn't tell us that much. So what is it that you do?
For the last 29 years, I've been working on Endangered Species Act implementation. And so one of the main things that I've worked on is getting species listed as threatened or endangered under the Endangered Species Act. Its listing is widely recognized as the keystone of the act because it's only once a species becomes listed as threatened or endangered that it receives all the protections of the act. So I've worked on writing. I'm a scientist by training, and so I've worked on writing the petitions to make the case that species do need to be listed, and then working with attorneys to make sure those petitions get heard. In some cases, when those petitions get denied, working with attorneys to get those not warranted decisions overturned. Similarly, when species get listed, the U.S. Fish and Wildlife Service or National Marine Fisheries Service are supposed to designate critical habitat for those species. So I've worked with attorneys to make sure that critical habitat designations happen. And then I've also worked extensively under Section 7, which is the requirement that federal agencies ensure that their actions don't jeopardize listed species or adversely modify critical habitat, and in actions that they fund, permit, or carry out. So we've often work to sue federal agencies when they haven't consulted, or to challenge biological opinions issued by Fish and Wildlife Service that aren't protective of enough of species. So basically trying to, keep the teeth in the Endangered Species Act. And I oversee 6 attorneys right now and a couple scientists as well.
Yeah, and those are the kind of cases that I see coming out of the center all the time. We don't usually do interviews on them because the legal issues tend to be relatively similar, but this case is very different because it's really looking at the overall, like what the regulations say, not how they're being applied to a specific species. And Section 7, which you mentioned, of course, is the big piece of this litigation and the part where you were particularly successful. And we can get into the legal specifics of the standing issue in the case as we discuss it. But for now, can you just lay out what a declarant is and why a declarant has such an important role in Endangered Species Act litigation and getting you into court?
Yeah, it's under the Constitution, right? Article 3 of the Constitution requires standing. You have to be able to show that you're harmed by what the government is doing. And in the case of species, you have to show that you have a concrete interest in those species, which generally you do by, saying, I care about that species. I go to visit its habitat. I hope to see it, and I have plans to do that in the future. And I've often been a standing declarant for species cases and spend a lot of time trying to see endangered species as part of my work and out of personal interest as well.
I'm sure you're very used to the fact that in order to litigate the Endangered Species Act, you have to find somebody who goes out into the woods and sees these animals. That's just a standard thing that you guys all know. But when you first hear this, it's like, what? This is nuts. This is really crazy. But this case is just, just like all the rest of them. And you had to get very specific about the species that, were in trouble because of this regulatory change. And before we get into the legal issues, can you just tell us a bit about your species, like who you were representing? And maybe there were a few declarants who came in and said, I really care about these particular animals or plants, and that's why I can litigate this case, or why the Center for Biological Diversity can litigate this case, and say we're doing it on your behalf.
Yeah, when we brought the case, there were a few species that were proposed for protections. And one of the things we were challenging is a change in the definition of foreseeable future. So a threatened species, well, so an endangered species is any species that's at risk of extinction in all or a significant portion of its range. A threatened species is any species that's at risk of becoming endangered in the foreseeable future. And so one of the issues at risk in the case was foreseeable future and how that's defined. And so I represented that there were a few different species that were proposed for listing as threatened. And under this new definition, perhaps they would not gain those protections if this new definition was applied. And that I'm trying to remember exactly which ones it was, but
I think I wrote them down.
Oh, you did?
A
Oh,
Mount
good.
Rainier
Oh,
white-tailed
yeah, I was
ptarmigan.
thinking it was the white-tailed ptarmigan. Yeah.
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 A white bark pine, because it's, we deal with the animals, but of course the Endangered Species Act covers both. Sierra Nevada red fox and Virgin River spine dace.
Right, a fish. Oh, yeah, that's
Oh,
right.
okay.
Yeah. And some of those actually have gotten listed as threatened since then, thankfully. The Mount Rainier white-tailed ptarmigan, which is a grouse-like bird that lives in winter conditions on Mount Rainier and several other Cascade peaks all year round. And white bark pine similarly was listed as threatened. The spine dace wasn't, and I think does in some ways reflect problems with these regulations. It's one of the things that it's a southern Utah fish, and St. George, Utah has been sucking too much water out of the Virgin River for decades and devastating the spine dace and several other fish species. And when they looked at climate change for the spine dace, they only looked to 2050, even though, there's climate change modeling that goes out to the end of the century. So they did really cabin how far into the future they looked, partially based on that weaker definition of foreseeable future.
I mean, it's good to see how these changes were playing out in the real world, and it's easy to forget that when you're only talking about the legal issues. But let's talk about the legal issues. I imagine most of our listeners are familiar with the fact that the Endangered Species Act exists, and probably somewhat familiar with it. But it's a pretty complicated act. And can you just start with you've already talked a little bit about what Section 7 does, but can you just start with an overview of what the whole act does and how it a brief overview of what it does and how it sets up this relationship between the government and other parts of the government and individuals and to protect species. All right, I just feel like I asked you a question that has an hour-long answer, but try to make it
Oh, no,
shorter
that's
than
okay. I
that.
can be concise about it. So it's, as I already mentioned, the act allows for listing of species, or I shouldn't even say allows, requires listing of species that are at risk of extinction now or in the foreseeable future. And once species are listed, it provides fairly substantial protections. One of those is Section 9 of the Act prohibits take of listed species. And take is defined broadly to include harm, injury, harassment, killing, shooting. And it's applied broadly. It says any person, but that's been interpreted to include, municipalities, states, in things that they permit. So it's got this broad prohibition on take of listed species. Then, as we mentioned, Section 7 puts duties on federal agencies to avoid actions that will jeopardize or adversely modify critical habitat. The way that federal agencies ensure that their actions don't jeopardize listed species is through consultation with the Fish and Wildlife Service for terrestrial or freshwater species and with the National Marine Fisheries Service for marine species or anadromous species. And so they consult with those agencies who, in the end of that process, produce a biological opinion that determines whether there's jeopardy or adverse modification. And if there is, provides reasonable and prudent alternatives to avoid that jeopardy. If there isn't, they also issue what's known as an incidental take permit. So they allow for take in exchange for reasonable and prudent measures to minimize that take. So it in many ways is the heart of the Endangered Species Act. It's where a lot of conservation of threatened and endangered species happens because of those reasonable and prudent measures that are required and because of efforts to minimize the harm caused by projects. And federal agencies end up permitting a lot of things,
Right.
Yeah, on public lands, things like logging, things like oil and gas drilling. On private lands, often, if you need any kind of federal permit, the most common one is under the Clean Water Act. If you're going to dredge and fill waters of the United States, you need a permit to do that from the Army Corps, and that brings in the consultation requirement in those instances. So it ends up having a lot of reach.
So it's not just things that the agency, whatever it is, the federal agency is doing, it's what they're permitting. And so that really means it's covering a lot of ground.
Yeah, and it kind of ties into the whole, I won't go into it because it's a whole different topic, but that whole waters of the United States under the Clean Water Act that's been back and forth for the last 20 years and at the Supreme Court matters a lot for endangered species because where there's jurisdiction, then endangered species get consideration. And so if all of a sudden you can plow a wetland over without it being, waters of the United States, then the Endangered Species Act does not come into place.
Yeah.
Yeah.
All right. Well, let's not go down that rabbit hole, but that is interesting. Yeah. All right. But I'm still not getting to the specifics of the lawsuit because there's something else preliminary I'd like to talk about, and it's a little bit about the politics. My understanding is that before 2019, the ESA, we'll either call it the ESA or the Act, implementing regulations had been stable for a really long time since, maybe since they were implemented like 30 years ago. And then there started to be these changes. Before we get to them one by one, can you just kind of give us an idea of what that was during the first Trump administration, what the government's stated goal in making changes was, and maybe a little backstory about the political turmoil about the act and what some well, I don't want to say real goals. I'm not asking you to put words in other people's mouths, but just the whole political mishigas surrounding this at the time. And surrounding it not just at the time, but since the act was passed, it has been under fire, but it got a little stronger in those years, right?
Yeah, I mean, what I'd say about that is, when it was passed, it was near unanimous. It was both the House and the Senate. It passed nearly unanimously. It was signed by President Nixon at the time, and it first ran into controversy around the Tellico Dam project in the late 70s, where the government was building this dam on the Little Tennessee River, and it threatened a species called the snail darter. And they were actually the whole dam was a boondoggle of a project. It actually flooded out really valuable farmland and displaced people. And part of the justification for it was the Boeing Corporation was going to build this like model city, which never has been built. And so it was kind of this gift to the Boeing Corporation. And So the justification for it were just terrible. But in any case, the opposition to the dam and its effect on the snail darter went all the way to the Supreme Court. The Supreme Court said, this law is clear. You can't drive species to extinction. And that's kind of where the controversy started. Um, Congress amended the act and included this provision, now known, it's become quite a bit more common in the lexicon now because the Trump administration has evoked what's called the God Squad.
If we have time at the end, I'd love to get a little bit more on what's going on with the God Squad.
Yeah, so they created this committee and allowed for things to be exempted. And the committee actually looked at Tellico Dam and concluded that it shouldn't be built, that it wasn't justified. But Congress stepped in and approved it through a rider. And so the controversy was there. And then, the Reagan administration came in and, with a really anti-regulatory mindset, which I think is really where you start to see that in the Republican Party, this anti-regulations for anything, human health, the environment. Moving into the 90s, I think where the modern Republican Party and its sort of anti-environmental agenda came in was in 1994 with Newt Gingrich and the Contract on America, as I call it. They passed a bill that prohibited listing of species, funding for any listing of species for a year. So we didn't see any listings or hardly any listings in 1994 because of that. And ever since then, they've really pushed this agenda of just stripping regulatory protections for our wildlife, for our water, for our air, for our climate, and have persisted in that. And I think the Trump administration has been incredibly rabid in that quest to just leave everything up to corporations and private industry and somehow think that's going to work out for all of us.
We'll get to the details of what they tried to do here, which are the center. That's what the interview is about. I promise I will get there. But all right. So I'm just going to start talking about the lawsuit rather than laying out all of the preliminary, and we'll discuss the actual regulation in the context of talking about the lawsuit. The lawsuit was brought in federal court in California by the Center for Biological Diversity, and immediately there was this big standing issue. You already talked a little bit about Article 3 standing, which is one of the functions you serve in bringing these types of litigation. And as many listeners know, there is a citizen suit provision in the Endangered Species Act. And since this is the Animal Law podcast and we're used to dealing with the Animal Welfare Act, which doesn't have a citizen suit provision, that seems like a very big deal, but it doesn't eliminate the necessity that you have constitutional standing and you can show injury. And the center is asserting organizational standing, which means that one of the things that they have to do is, as you mentioned, show that you and other members have been injured, and injury is always the centerpiece of constitutional standing. And then the government raised a million different standing arguments. I'm just wondering, I think the court even referred to it as a kitchen sink approach, that they raised every possible standing issue that they could. Just a preliminary question, was this unusual? Is this a new tactic that they're going to start to attack the possibility of standing in cases where it has formally been kind of accepted that organizations like the Center for Biological Diversity would have standing?
We weren't totally surprised by it because it is a facial challenge to regulations, so they tried to argue essentially that we can't bring that case because there's no specific standing to a facial challenge. We'd have to wait until some project that relied on the regulations was harming a species and then bring it then. And I'm glad the court didn't limit it to that because, I do think we are injured by these regulations. And I do think, having to wait for the specifics would have been painful. It would have caused additional injury, I think. So, that was the main hurdle we had to get
Right.
over, was that this was a facial challenge to regulations. Could we show harm to our interest in species by, sort of essentially, prophesizing how these regulations would harm species. And so we found very specific examples of how that could happen. So for example, one of the things we challenged was when looking at adverse modification, the regulation said that a project would have to harm critical habitat as a whole, rather than just the critical habitat that's in place where the project is. And so we, there was a really good example of that. There's a proposal to build a dam on the Pearl River, in Jackson, Mississippi, and the Gulf sturgeon is a species that has critical habitat from basically Texas to Florida. And but the Pearl River is one of the places that they spawn. And so under that regulation, if it's as a whole, you could say, oh well, you can dam this one river and eliminate the spawning habitat for the Gulf sturgeon, and that'll be just fine because it has other places. And so it was a good example of how the regulations specifically harm our interests.
We can get into that a little bit more when we're talking about the substantive arguments, because that was one of the examples I noted as well. But yeah, I can see how it would also. I didn't realize that this was actually kind of a legit no, not a legit argument, but a viable argument, a colorable argument. That the standing to the facial challenge was more potentially controversial than the obvious kind of thing that you usually litigate, where you're talking about a specific species, and you can show how the injury would occur. So that does make sense. I did notice, though, not only did the court call it a kitchen sink approach, because there were a million other standing arguments too, which I won't go into. But there was one. It was in a footnote too, and about Lujan. And the court said that the government's arguments grossly misrepresents the statute in Lujan, which was the case they were talking about. I did feel the court was felt that maybe there was a little overkill in the standing arguments here, but you did get standing. And unless there is another standing argument that you would specifically want to address, I'll move on to the substantive arguments.
No, I mean, I would note that, standing is frustrating in some instances. With some species, it's hard to go out there, and see them. And so that goes back to a Supreme Court decision, Bennett versus Speer. And it's unfortunate in some ways, because I think people can clearly have an interest in a species without going out to see it, and so I think that limitation is unfortunate. He actually passed away, but there was a scientist that I used to work with named Jim Deacon. He was a fish scientist, wore his heart on his sleeve, very good guy, but he was in a chair. He'd had a spinal issue. I can't remember exactly what it was, but he was in a chair for the last, 20 or 30 years of his life. And I always thought, boy, like, somehow Jim Deacon, these fish species that he studied for and cared about, loved really for decades, somehow he wouldn't have standing. It always struck me as just wrong.
The standing litigation is, I mean, as I mentioned before, it's insane. Like, it's just insane. I mean, and from an animal law perspective, it's even more insane, because you don't even have a cause of action. And I'll go on to this case. I'll get back to this case. All right. First, I'll just mention that there was no question that this was a case that was appropriate for summary judgment, which is what we're dealing with here, a motion for summary judgment that was granted in part and denied in part. There were no factual disputes to be resolved, and it just, as you mentioned, resolved whether the regulations were facially inconsistent with the Endangered Species Act. Some of the claims were actually whether they were arbitrary and capricious under the Administrative Procedure Act. And I think there was a NEPA challenge, but there's no way we're going to have, unless you really, really want to go into the NEPA challenge, there's no way we're going to have time to do that. And all of the regulations that the court found to be improper were under Section 7, which you've already talked about. And is there anything you want to add in this context to how Section 7 governs the relationship between between what we'll call the services and what we'll call, I guess they called it the acting agency, which would be the agency of the federal government that is trying to do something that might be in violation of the act.
Boy, there's a lot there to unpack over the years, of things, how that's applied. I mean, just maybe I'll just mention one thing for context, which is that, one thing that's hard about the Endangered Species Act, right, is that in many ways, government is in place to, the way I usually say it is to grease the skids, right, to encourage economic activity, to facilitate economic activity. That's often how government operates. That's how they see themselves. And the act was particularly challenging in that it recognized that there was an economic conflict, or that there were often economic conflicts between saving a species and between whatever activity is ongoing.
Clearly.
And so it put the Fish and Wildlife Service and National Marine Fisheries in the place of having to say no to economic activity in order to save species. And that's an uncomfortable position to be in. And in some ways, they've run from that as much as they can. So, for example, they rarely will determine that a project jeopardizes. They'll go to great lengths to avoid saying that a particular project jeopardizes. And so they almost never outright deny projects. Sometimes projects get slowed down in part because of our litigation and they kind of die under their own weight. But it's rare for the Fish and Wildlife Service to say no. So it's kind of in that context that we end up litigating and end up fighting for species, is always trying to push Fish and Wildlife Service and National Marine Fisheries to do more and to make sure that the species really will be okay. It's challenging.
Yeah. Yeah. I've never thought of it as that difficult, but because I'm used to thinking about the USDA and animal agriculture, which is an even more well, perhaps as much of an agency that is devoted to the business it regulates, and to say that they shouldn't be allowed to do things. It's a very similar kind of situation, I think.
Yeah, I agree. And Fish and Wildlife Service, it always has had an extra element of frustration to it in that their mission should be clear. Their mission is to protect the species,
Yeah.
you know.
Yeah.
Whereas you're right, USDA, their mission is partially
Feed
just
feed America.
feed
Yeah.
America, right? So
Yeah.
they have much more conflict there than it would seem Fish and Wildlife Service had. But Fish and Wildlife Service is a small agency and gets pushed around a lot, and yeah, so it often is unable to get to a place where it can really fulfill its mission as much as you would hope.
So let's get to the regulations. The first two regulation changes that the court dealt with were changes to the consultation requirements. So can you explain to us what consultation is and when it is required under the statute?
Yeah, so it's required anytime a federal agency action may affect listed species. And that's been found to be a pretty low bar. Like if there's a chance that you're going to be affecting a species, then you need to consult. And that is pretty detailed in the statute how that process occurs. It begins with the agency providing a biological assessment, looking at what effects they think it has, Fish and Wildlife Service taking that biological assessment and then producing a biological opinion that has reasonable and prudent measures. And the regulations, they were actually from 1981, so from the Reagan administration going back to then, said that, in looking at projects, they had to look at interrelated and interdependent actions. That was part of it. So it's, you're building, it's the Transportation Administration building a highway or funding a highway. What effects, are going to stem from that highway. There's going to be development, and how's that development? So they've had to, the idea was that they had to consider all the possible effects of the action in question as part of the biological opinion and ensure that those effects are minimized. And so part of the regulations, really struck at that, really tried to limit how much sort of ancillary effects would you look at. And so they said they would only, say you're building a highway, they would only look at the development from that highway if it wouldn't occur but for that highway and if they were reasonably certain to occur. So they really tried to cabin the effects of the action and what was minimized to the specific action itself. And in a climate context, and actually so far they're still getting away with this. They won't look at emissions and how emissions affect species because they say they can't quantify it partially, but they also say it doesn't meet that but-for test. Emissions are a global phenomenon. Even if the government's permitting, say, a new coal plant or oil and gas drilling on the outer continental shelf, they're not going to look at how that will affect species because it's part of this global process, and global warming will happen anyway. It doesn't meet that but-for test, which is unfortunate. So that was the first part of what we challenged and what we won on, is that hinging on but for and reasonably certain to occur. And the court found that it's inconsistent with the statute because the statute says when producing a biological opinion, when analyzing the effects of the action, they have to rely on the best available information. And that's been interpreted by the courts to mean available, not perfect, not certain. And so the court concluded reasonably certain to occur violated that essentially it was a higher standard. And you could say, but we don't know if that development's going to occur because of the highway. It's not reasonably certain to occur, so we don't have to analyze it. Mm-hmm. Even if there was information to say, well, clearly that's why they're building the highway, is for this development, and so that is likely to happen, and therefore it should be looked at and minimized.
I have that in my notes, and which could easily be wrong. But that the real focus that I focused on was the difference between what you just said, likely to occur, which had been the standard, and to this shift that you mentioned, reasonably certain to occur. Was that difference a touchstone for the court? Because I have to say that the difference between likely and reasonably certain to occur seems really obvious. They don't mean the same thing. Even in common talk, even in common chatter, I'm likely to go to the store later. I'm reasonably certain I'm going to the store. I mean, they mean different things in English.
I think that's right. And the court did really key in on that. And I think they, and I mean, one thing that the court keyed onto as well, and that I think was right, was, the defendants tried to essentially make that argument like, oh, it's the same, and then the court was like, well, if it's the same to you, then why even make the change? And so they're like, that's completely disingenuous, and
that's hilarious.
I think it was clear that they were making the change because they wanted to limit the scope of consultation to the actual, just the footprint,
to only things that you can say are reasonably certain to occur if we build this highway.
Right. Yeah. Whereas likely is just more likely than not. Like probably going to happen, and we should look at that.
That is really funny. Like the statute says likely, they changed it to reasonably certain to occur, and then they said, well, they mean the same thing, and the court's like, well, then why did you change it? Yeah. All right. I know that the court also found that the change was arbitrary and capricious under the Administrative Procedure Act, and I'm assuming that the difference in whether something was found to be facially invalid or invalid under the Administrative Procedure Act has to do with, if it's facial, it means that it contradicts the Endangered Species Act. And if it's arbitrary and capricious, it means they didn't follow the appropriate procedure in doing this. Is that right?
Yeah, they didn't explain, is what the court found. That if you're going to make a change, like you have a long-standing regulation and then you change it, you have to have some reason for that. You have to explain that. Otherwise, it's arbitrary and capricious. And they didn't offer a good enough explanation. What they said was, it used to be that there were indirect effects and interrelated effects. And for indirect effects, they did use that reasonably certain to occur language in the regs before. And they said, well, we were just making it consistent. We're just having it applied to any effects that we're looking at.
Yeah.
And that's, it's clear. That was their explanation, which isn't an explanation at all.
No,
And so
like
the court,
we were wrong before, so we decided to be wrong again. All right. That's all I have on that the first issue. If there's nothing else, I can go on to the second issue, which also related to Section 7, consultation, and I think was a different aspect of the same regulation. Is that right? And it had to do with ensuring that a project will not jeopardize listed species. Am I right? And there was actually there's a Ninth Circuit decision which I thought was interesting, talking about having a stated intention to make them. If you want to go into that, feel free.
Yeah, that was a really important finding because in several cases the courts have found that agencies can often promise to do things, or even private entities. Actually, we had a case over a pipeline that they were going to build in Oregon called Ruby Pipeline, where they tried to do this. They had various measures as part of the proposed project that they said they were going to do to try and avoid impacts from this pipeline. And Fish and Wildlife Service tried to rely on those, even though they're not essentially terms and conditions in the biological opinion. They're not enforceable, say, by us or another outside party. If those aren't, they're just in the project description. And, they were essentially, what the regulations tried to do was to say that if an agency or a private party said they were going to do something, made some big promises about doing something, Fish and Wildlife Service had to accept that on its face. They couldn't question it. They couldn't say, yeah, but do you actually have funding for that? Do you actually have concrete plans to do that? And so I was really glad to see that get rejected, because people can promise all kinds of things in
Like,
order
do they
to
live
avoid,
in the real world? Like,
yeah,
what are they
exactly.
even talking about?
Yeah, exactly. And so I was really glad to see that overturned. And, what it essentially says is, if there's terms and conditions to minimize the effects to a listed species, those have to be binding terms and conditions, and they have to be enforceable. And so that's really a good outcome.
So there's some kind of contractual or other way in which the promise can be enforced.
Yeah.
Yeah.
We, for example, as watchdogs, the Center for Biological Diversity could read the biological opinion and say it requires X, Y, and Z. X, Y, and Z didn't happen, therefore they're in violation, and go to court over that. But if it just has vague promises in the project description and says, oh yeah, we're thinking about doing this, then
That's insane.
And then they don't do it. Yeah, it is. It is insane. It's true.
The third one is also insane. And this has to do with adding 3 words, and 3 words like really changed it a lot. And this is not about consultation. This is about
well, no, it is still about consultation.
Oh, it is. All right. Then I misspoke.
Yeah, because under the Act, under Section 7, one of the things they analyzed during consultation is there adverse modification of critical habitat. And so what the regulation said is that they would only look at the critical habitat as a whole. So you picture, it applies especially to wide-ranging species that face a lot of threats. So the northern spotted owl, logging is a primary threat to that species. And essentially it has over 9 million acres of critical habitat. So it said essentially, for a project to be considered adverse modification, it has to affect the critical habitat as a whole. And when you think about that,
as opposed to before, that as a whole language wasn't in there. It just said it had to affect the critical habitat.
Right. It had to diminish the critical
habitat.
And, so you picture, there's no clear cut in the world that would be big enough to affect 9 million acres as a whole. So you could be cutting down, old growth habitat the spotted owl needs. And it really leads to this problem of death by a thousand cuts. That each little project isn't determined to adversely modify, but then when you add them all up, it really harms the species. So I was glad to see the judge agree with us about that.
This is particularly uh, very unscientific. I mean, they're really not looking at what a species, or what certain species anyway, are and what they do and how they live. And there's just either an ignorance or a willing refusal to accept that animals' habitat is what animals' habitat is.
Yeah, and it really goes back to this idea of just not wanting to stop economic activity, not be in the position. And honestly, Fish and Wildlife Service has rarely said that there's adverse modification. Similar to Jeopardy, they rarely say it, and you know, I the Trump administration, in enacting the regulations, essentially wanted to, blow any Endangered Species Act enforcement out of the water. But the Biden administration retained that part of the regulations when they revamped the regulations. So we were actually challenging the Biden administration on that, and it kind of shows that there's a level of bipartisanship to avoiding regulations and wanting to have clear boundaries.
This was also the area you talked about this case before, which had to do with the sturgeon. It was the same kind of thing that they there was a certain part of the sturgeon's habitat that they said they could eliminate because they had lots of other habitat, but it
Yeah,
was actually
exactly.
very crucial.
Yeah, exactly. It's the Pearl River, and we're actually still waiting for a record of decision on that dam. It's a dam that would be built in Jackson, Mississippi. There's already one dam there, and this would add a second and create this. It's similar to Tellico. When you really dig into projects, oftentimes there is just some very specific economic interest. So it'll
Like
create,
somebody's making a buck.
right, somebody's making a buck. Like
Yeah.
they're gonna have this lake shore in Jackson where people can build casinos and resorts and stuff like that instead of having a natural river with the riverfront. So
Yeah.
it's one we're waiting on the decision from any day, and we'll certainly fight.
With your experience, I guess it wasn't as shocking, but reading it cold, that was the one that really shocked me, that it would be seen as, because their argument was basically like that it just didn't make a really big difference. And it's so obvious that putting those three words in there would make an unbelievable difference if you're talking
Yeah,
about habitat. Like, it
very
doesn't
much
make.
so. Yeah.
The last one that you were successful on is also under Section 7 and has to do with the the services have a duty to flag when a consultation needs to be reopened, and it was trying to eliminate that. Is that right? Can you explain what happened there?
Yeah, so once there's been a consultation and there's a biological opinion, the regulations have always specified there might be conditions where that consultation needs to be reinitiated, is the technical term that they use, but reopened works as well. And those were, that the impacts were more than previously considered. A new species was listed, or in a lot of cases, just it's not being followed. It's not working, and so it's a part of the regulations that they've been trying to get rid of, and actually Congress has stepped in some ways. So it's already been narrowing, but it's one of the key ways that biological opinions get enforced is if it's not working, then you got to go back to the drawing board. And what this regulation said was it's only the action agency's duty to reinitiate consultation, and Fish and Wildlife Service essentially just washes their hands of it. They don't have
That's
any.
also insane. Also
Yeah,
insane.
yeah. So I'm glad that was rejected in Fish and Wildlife Service. If they have information, they need to let the agencies know that they need to reinitiate, and that's the case because of this decision.
To make clear, I mean, assuming I'm right here, they can't even it's not that they have the right to force reinitiation. They just have a right to like request it. Is that right?
Yeah, exactly. Yeah, they
Like,
just need to let them know. Yeah, and they
that's
were trying
so,
to run away from that. Yeah.
and I mean, this is obvious, but like, who would be in the better position to know when new information requires reopening consultation about endangered species? The I don't
The
know,
expert
the
agency. Yeah,
highway
exactly.
department,
Yeah, exactly.
transportation
Exactly.
department,
Yeah.
or Fish and
Yeah.
Wildlife Service. Like,
Yeah, exactly. Yeah.
just to be a completist. This was also found arbitrary and capricious under the um, Administrative Procedure Act. I noted that.
Yeah,
But
similar again of just they really provided no explanation why this change was needed.
all right, so those are the four. I mean, four hugely important. I mean, when you start talking about them, it doesn't. When you first hear it, it's like doesn't sound that big, and you start talking about them, and you realize the scope of these changes was very big. But there were two provisions that survived. Do you just want to? I don't know how important these are to you, and I was wondering too whether the court's decision resolved some of the problems you were worried that it interpreted the changes in a way that might have made the fact that they survived um, not as dire. But can you just tell us what it is that the court did not find were problematic?
Yeah, it's unfortunate. So I mentioned that when a species is listed, there's a requirement that critical habitat be designated. And there's an exception to that where they can find critical habitat not prudent if it won't benefit the species. And actually for years throughout the 80s, 1980s, Fish and Wildlife Service routinely didn't designate critical habitat. And still to this day, I haven't calculated a stat in a while, but it's, roughly 40% of species don't have designated critical habitat. And so, the courts cabined that, constrained that pretty considerably in the 90s, saying that, it should be a really rare circumstance. And so, since then, they've limited it to situations where species are collected, where there's some threat of poaching and where perhaps publishing maps of critical habitat would facilitate that. I actually don't think it's a great justification in most cases. Most cases, it's publishing, sort of a coarse scale map, say designating watersheds. Like an example of a species that didn't get critical habitat is the Ozark hellbender. It's North America's largest salamander. It does appear in the pet trade and is something that's collected at times. And so they didn't designate critical habitat, but it's, if you publish these, maps that show broad watersheds where critical habitat is designated, it doesn't really give much clue to where you would go collect one. So even in those instances, to me, it's not terribly justified, but that was kind of the limitation of when they really wouldn't designate critical habitat. And they've opened that up considerably with these regulations. And the one that I find most concerning is that they say when habitat destruction isn't a threat, or maybe even isn't the primary threat, then they won't designate critical habitat. And, I think a lot of this is, the agency's running away from climate change.
Oh,
They don't want to designate critical habitat for climate change impacted species. We mentioned a couple of them actually. Mountain Rainier white-tailed ptarmigan. Climate change is the primary threat, but it has some threats to its habitat too. And they actually have reversed course. They originally said it wasn't prudent under these regulations, and then when they finalized the listing, they said it was not determinable. So they still are open to doing it. But whiteberg pine, for example, it's threatened by climate change and as well as an introduced disease. And so they didn't designate critical habitat for it. And, I think it's really unfortunate. In some situations, you might need to designate critical habitat where a species currently doesn't occur, say like a species that's impacted by sea level rise. you might need to designate critical habitat inland in order to ensure that it has habitat in the future. White bark pine or Mount Rainier white-tailed ptarmigan, I always thought, well, you should try and figure out where the climate refugia will be. Where will the species most likely be able to survive, and designate that as critical habitat to ensure nothing happens to those areas. And so it's, the court essentially said, they're gonna they're gonna look at the critical habitats and they're gonna determine if there's a benefit or not, and they may determine that habitat destruction isn't a threat, so that there's no benefit, and determine it not prudent. They upheld that part, which I think is unfortunate. I think and really Congress was quite clear that not designating critical habitat should be a rare instance, and this definitely opens the door more.
What are the implications of designating critical habitat?
Yeah, so the main one is through Section 7, as we said that, as part of Section 7, Fish and Wildlife Service determines whether a project will adversely modify critical habitat. One of the things that's really important about it and doesn't get enough attention is that, generally species are protected where they are. Consultation will only be triggered where the species still occurs. Most species that are threatened or endangered have lost substantial, maybe 90% or more of their range. And so critical habitat's the one place where you can identify areas that are important for recovery of species and provide some protections to those places. So you could have a situation where an area has been defined as critical habitat, but the species no longer occurs there, and that would get some protections through Section 7. But it also provides other benefits. It's educational. People have no idea if they have critical habitat on their land or not. And, this lets them know that they do. And in a lot of cases, for private landowners, if there isn't a federal agency nexus, they're not really affected by critical habitat. We own some property that has critical habitat for Oregon spotted frog on it. And, we love that, and actually we've had Oregon spotted frog egg masses in a pond that's on the property. So it's information to the world that there's something important here.
But it does limit what you can do, right? I mean, it's not just informational.
If you need a federal permit, it does. So if you're gonna modify waters of the United States, I mean, honestly, I wish it limited people more than it does. It really only comes into play if there's that federal nexus.
And there was another regulation too regarding the definition of foreseeable future.
Yeah, this is in regard to threatened species. And so in this case, reasonably certain to occur, unlike in Section 7, was found to be okay. So that, they defined foreseeable future as the threats to the species in the future, and the effect of those threats on the species are reasonably certain to occur in the foreseeable future. And in this case, the court determined that that was okay. And, unfortunately, they've been really trying to limit how they look at threatened species and how far into the future they look. And a lot of this has focused on climate change and whether those effects are foreseeable or not.
Well, that kind of covers the appeal, but I have a few follow-up questions because I'd like to talk about the bigger implications. But first of all, I mean, since do you expect that the government will appeal, and do you plan on appealing, or have you decided yet?
We're still waiting. They haven't filed a notice of appeal yet, but we wouldn't be surprised. And I didn't mention the sort of weird procedural thing that has happened here, which is, 2019 Trump administration puts these regulations in place. We challenge them. The Biden administration comes in. They ask for a remand. The with vacature, the court initially grants that, but then there's a Supreme Court decision that you can't have vacature without a decision on the merits. So that comes back to the court, Actually, I think it even went up to an appeal. And the court ends up remanding without vacature. Fish and Wildlife Service puts in place new regulations that fix some of the problems, but not all of them. We continue our challenge. We get a decision. But in the meantime, the Trump administration has proposed regulations again, which, seek
Right.
to put back in place some of the things that the Biden administration fixed. And so now we've gotten this decision, but we're waiting for the final regulations to come into play, and that could happen anytime. So, I mean, I do think they probably will appeal this decision. I'm not 100% sure of
Well,
that.
I was trying to avoid this whole
Yeah, it's
procedural, but
very
there wasn't any way
confusing.
to do it.
Yeah,
But I was wondering, like, all right, so there's new regulations that are coming out. What is the effect of this ruling on those regulations? Are they gonna, if they don't appeal, are they gonna have to comply with this ruling in their new regulations?
I think so. I mean, I think particularly for as a whole, and well, all of those Section 7 wins. I mean, they certainly, I mean, as a whole, that was already still in there, so they're going to have to do something with
Yeah,
that. So, it's hard to say how they're responding to
yeah,
this and what they're going to do, but I think appeal is certainly
yeah.
possible. And I
The
think we're
story's not
waiting.
over.
Yeah, we're waiting to see if they appeal to make a decision on whether we appeal on those Section 4 parts as well. So we haven't made a decision yet.
So another thing that I wanted to ask you is not about this case, but did we mention at the beginning, or was that before we started recording? I don't remember. But the God Squad situation. Could you just give us like the very briefs? Because I know that's the other huge, huge issue that's in the news right now about the Endangered Species Act. Can you tell us what the God Squad is and why everybody's talking about it?
Yeah, so as I mentioned, after Tellico Dam, Congress amended the act and added this, what's in the act called the Endangered Species Committee, but has been referred to as the God Squad. And it laid out very detailed procedures. And the committee is made up of, Secretary of Interior, Secretary of Agriculture, the head of the Council on Economic Activity. It's like a cabinet level.
Yeah.
And
Already it sounds bad, gotta
yeah, it's
say.
bad. It's especially when you look at this cabinet.
Yeah, that's what I mean.
But
Yeah.
but it has very clear procedures in there, and essentially it requires that certain things happen. And one of those things is that there's a biological opinion. That biological opinion determines jeopardy, that a project like Tellico Dam will jeopardize and cause the extinction of a species. The agency has gone through, looked at the reasonable and prudent alternatives, and does not believe that it can implement those, that the RPAs are not possible. And then there's an application to the committee, either from a state or from an action agency or from, whoever's, building the dam or whatever it is. Then there's supposed to be this whole, essentially a trial, that's open to the public and proceedings and findings, and then that all goes up to the committee, and the committee makes a decision. And it can essentially, the reason why it gets called the God Squad is because they can essentially say, this project is so important that, we don't care if it's going to it's going to drive a species towards extinction or to extinction, and therefore it can go forward. It's only been evoked 4 times. And there was one time in the 1990s. That was the last time. So it hasn't been evoked in, 30 years. And they did actually allow some timber sales that threatened the spotted owl on BLM lands to go forward, which was unfortunate. But in this case, none of that has happened. So there wasn't a biological opinion that found jeopardy. There wasn't an application
Uh-huh.
from an action. There was none of the procedures that are detailed in the statute have happened. And instead, they just called the committee together. And I don't know if you've watched the video, it's pretty amazing. And they just decided, well, I should add that there's one provision in there that says that they can do this for national security reasons. That's one of the bases. But it's also pretty clear that all those other things have to be met before they determine that.
It's not like it's an exception to all of the procedure. It's just one of the reasons you can invoke the procedure.
And so they brought everybody together. They had Hegseth there, and Hegseth says, oil and gas drilling in the Gulf of Mexico is important for national security, and therefore all oil and gas drilling in the Gulf of Mexico is exempt from the Endangered Species Act. And the species of concern is a whale called the Rice's whale, which is down to a very small number of individuals in the Gulf of Mexico and at risk from ship collisions. And so there's some sea turtles as well. So they're saying essentially oil and gas drilling can go forward without any consideration of whether it drives these species to extinction.
So
that's something we're challenging,
and it's being
in court.
litigated. Yeah.
We're challenging it in court, and actually everybody else is as well.
Yeah. Not surprising, but once again shocking. There's a lot going on that's not surprising but shocking. So assuming we manage to get through the current political crisis and have an opportunity to rethink how we're going to protect the environment with a real government that really cares about things. How do you see the next chapter? Obviously taking into account, not ignoring climate change anymore, but taking it into account. Is the Endangered Species Act, right now it's kind of the centerpiece, or at least one of the kind of the centerpiece. And it's still useful? Is it up to the task? Or even if enforced, are we way behind and we need something very different? All right, this is a big picture question, but I'm sure you're up to it.
I think the law itself is very much up to the task. It's whether the government is up to the task of implementing it. And, we've had, during my career, just watching it swing from Republican to Democrat administrations, we've had this swing where Republicans come in and they basically just try and dismantle the regulatory state. By the Trump administration, the second term has been just a wrecking ball. We've seen attempts. The Bush administration tried to put in regulations for ESA implementation too. So we've seen that playbook. We haven't seen the playbook of just trying to fire all the scientists in the government, trying to essentially pull the government out of science, this is the most anti-science administration I think we've ever had, ever. I think but then when we've had Democrat administrations come in, they've sort of been like Republican light, they're like, we want to let the agencies do their job, but we don't love regulations either, and we, want to be friendly to business. And, so that's been their take. And what we really need now is we need an administration that comes in that says we need regulations. They're essential to protecting our future, to protecting wildlife, to protecting our climate. We need regulations. We need agencies that follow the science, and we need the funding for those agencies to do their jobs. And we just haven't had that. And so, I would love to see an administration that comes in and really just recognizes the importance of regulation for protecting the environment, for protecting human health, for, the whole shebang. Yeah. And that's just hasn't been part of the conversation. And I blame the Clinton administration a lot for that, because they came in and they were essentially, pulled to the right and, and sort of normalized Democrats pulling to the right, I think.
Yeah. We could spend many hours talking about what's gone wrong since the 70s when this law was passed and things were looking so good, and why since then it hasn't been seen as the first step to protecting the environment, but as the absolute final ultimate, which we have to protect constantly against attack. So yeah, we need a different attitude. Well, this has been extremely enlightening, both in detail and just more generally. Anything you want to add before, anything I didn't ask you that I should have, that you want to add before I let you go?
I'll just note, scientists from around the world are warning that we're in an extinction crisis and that this really threatens to unravel our way of life. Species are the building blocks of ecosystems, and ecosystems, moderate our climate, clean our air and water, cycle nutrients, provide us medicine, provide us food. And as we lose more of the parts, we undermine the function of those ecosystems. So it's really a crisis that's on par with climate change. And I don't think that's widely known. I think climate change has come into the consciousness and people realize that it's a very serious threat. But extinction is right up there with climate change, and it's really important for people to recognize that. And I would note that they're also very interlocked. Habitat destruction is the biggest cause of species extinction, but it's also a very significant cause of climate change as well. Just, ripping up forests and plowing and all that stuff also results in a substantial amount of emissions. And so to address both, we have to protect more of the natural world. And, I can't emphasize that enough.
Yeah, and I'm glad you said that because, everybody listening, I imagine everybody listening is totally on board. But as animal lawyers, we tend to think of the animals as important in and of themselves, which is rare. Like, we're proud of that. But also, all these are all the arguments, and we would like to survive as well, and we would like the earth to survive as well. We're just because we don't focus on that as much. So I'm talking about we, like everybody. I, I think animal lawyers are very aware of all of this, but it is a different focus, and having those arguments and being aware of it and how important the extinction crisis is to our survival. Animal people sometimes don't focus that much on humans, but that's the argument that works. So yeah, and I would like to see humans survive, maybe some days.
Yeah. A better version of ourselves at the very least.
There we go. There we go. The good guys, only the good guys. All right. I'm going to let you go. But this has been so enlightening. I really appreciate it, Noah. Thank you so much for joining us today. And thanks also to Vicky Beechler and Akbar Khan for their help in producing the podcast. Thank you out there for tuning in. And please remember to subscribe on your favorite podcatcher or on YouTube. And see you next time.